New York's vast public transportation network is a huge convenience for residents, but it's also susceptible to wear and tear and inclement weather. Try as they might to fix dangerous conditions and prevent accidents, station operators and workers are constantly playing catch-up. The result can be slip and fall accidents, which can lead to hefty medical bills, time off work, and even life-changing injuries. But with an experienced attorney, victims can hold these public entities accountable through a personal injury lawsuit. Who is liable? Slip and fall accidents on public transportation most commonly occur at a public transportation facility, as well as while on entering or exiting a public transportation vehicle like a bus or train. Liability for injuries sustained in an accident at a public transportation facility turns on the legal concept of premises liability. Basically, this means that those responsible for a property have the duty to maintain the property in a reasonably safe condition. But figuring out who is responsible isn't always straightforward. An example is the real-life case of Garrettson versus the town of Islip. Mrs. Garrettson filed a personal injury lawsuit after she fractured her ankle slipping and falling on snow and ice that had accumulated on a walkway between a commuter parking lot and the Central Islip Long Island Railroad train station. Her attorney sued three parties: the town of Islip, the Metropolitan Transportation Authority, and the Long Island Railroad. The court had to decide which of these parties, if any, were responsible for maintaining the safety of the walkway where Garrettson fell. It ultimately decided on the town of Islip. The key takeaway is that figuring out who can be held responsible for your accident will likely require some detective work by your attorney. The storm in progress doctrine. Many slip and fall cases that happen on public transportation property involve bad weather. It's hard to keep platforms and walkways clear and safe through a storm. This is where the storm in progress doctrine comes into play. It essentially says that those responsible for a property aren't required to clean up during an ongoing storm, nor during a short break in a storm, nor for a reasonable time following a storm. The storm in progress doctrine helped the New York City Transit Authority escape liability in the case of Riper versus New York City. For example, Mrs. Ripers filed a personal injury lawsuit after she slipped and fell on wet stairs at a New York City subway station. The court ultimately dismissed her lawsuit because weather records showed it was raining at the time of and for hours before Riper's accident. According to the court, the New York City Transit Authority was under no duty to address dangerous conditions resulting from the rain while it was still raining or for a reasonable time after the rain stopped. Suing a public entity is complicated for a number of reasons. The law recognizes that public entities are special when it comes to lawsuits, and its solution is to make it harder to sue them. If you want to sue for compensation after a slip and fall accident at a public transportation location, you also need to file what's called a notice of claim within 90 days of the accident, which is pretty soon. So, you must contact Rosenblum Law immediately for a consultation. We have decades of experience successfully fighting for victims. We'll determine who's liable and prepare the best case possible so you get the compensation you deserve.